which is Leone, Farah versus Diaz, case 24-2919. We'll wait just a second for the dust to settle. All right, counsel, you may proceed. It's 5 minutes for rebuttal. Sufficient?
Good morning, Your Honor. Yes, that's
Okay,
good.
great.
Good morning, Your Honors. May it please the Court, Kimberly Burman on behalf of the appellants Bradley Leone, Esquire, and Barrett, PA. Your Honors, this case is about an arbitration clause and a retainer agreement between a lawyer and a law firm and a client. The question has to do with whether or not we have a valid arbitration agreement, the first test in the Seifert test, the first prong, excuse me. Here, the lawyer and law firm did not sign it. The court found that that was fatal, and the client signed it before she became a personal representative, and the client found that that was not binding on the client. The trial court erred in the following reasons. First, the arbitration clause in the retainer agreement complied with the rule regulating the Florida Bar 4-1.5I. Second, the failure to sign the agreement on behalf of the lawyers and the law firm was not fatal to the entire agreement.
It would be fatal to the contingency fee agreement, correct?
It was fatal to the contingency
So are you
aspect.
trying to sever out the arbitration agreement?
Yes, we are trying to do that, Your Honor. That
So
is
the
what-
arbitration agreement was inside the contingency fee agreement?
It was the last paragraph, it complied.
So why is the contract as a whole not void?
Because the contract as a whole, if you look at the rules regulating the Florida Bar, the entire 4-1.5 has to go with costs and fees for services. It can deal with contingency fees. F, paragraph, subsection F, deals just with contingency fees. The requirement that you have to have a writing signed by the lawyer and law firm only applies when you are trying to deal with a contingency fee and collect on it. We're not trying to do that here. This is a legal malpractice claim. The language in the agreement and the arbitration clause specifically says that if any claim for arbitration arising out of this agreement, including and especially claims for professional negligence, breach of fiduciary duty, which is the claims that we have here, are to
Does
be
the Florida
arbitrated.
Supreme Court, I think in the Chandra's case, don't they address this same issue? And
They-
talking about contingency fee agreements, that the contract as a whole is unenforceable?
In the yes, in the Sandra's case, they did discuss it, but it was a very different circumstance. In that case, it had to do with a non-Florida lawyer that sought to enforce a contingency fee agreement that wanted to collect a fee. And so if you look at the Sandra's case and read it in a very broad language, the policy was that they weren't going to be able to regulate this non-Florida lawyer. In this case, that's not what we're trying to do. We have a Florida lawyer. So there's nothing that we had in Chandra's is applicable here. And it did not deal with the arbitration agreement. It was whether or not a contingency fee could be collected by the non-Florida lawyer. And in Chandra's and the other cases, ultimately the courts, when they tried to give fees, they gave quantum merit or quantum merit, however you say it. They still were willing to give the fees to the lawyer. So for purposes of Sandra's, that case cannot be read as broadly, and I would refer your honors to Justice Sasso's dissent in the Harmon Parker case, and she detailed that and explained how you shouldn't go into the holding and spread a holding out when it's a completely different circumstance, because it's not like you're applying a statute, you're not applying a rule. And it also, in the Chandra's case, that was before the current iteration of the rules regulating judicial or professional conduct were even enacted. That was pre this current procedure. We also have the preamble, which talks about the circumstances in which you would make a fee agreement unenforceable. And we also have 4-15D, which talks about how contingency fee agreements and agreements in this contacts are ordinarily going to be deemed enforceable unless they are illegal, unless they are prohibited by law, unless they are excessive. We don't have any of that here. The court hasn't found that because we're not trying to enforce the contingency fee. The client is not trying to say we don't get paid. The client has sued us for legal malpractice and a breach of fiduciary duty. And the arbitration clause complied completely with what needed to be in the arbitration. So if you look at the Ramilton case, compare that case, there was a slight tweak in the language of the arbitration clause, and the court affirmed a ruling compelling arbitration of a legal malpractice dispute. The Johnson Pope case, that case said that you can arbitrate legal malclaims. There's nothing wrong with that. It's not a violation of public policy. It's not illegal to do so. The case of...
Counsel, let me ask you this.
Yes.
Since legal practice and collecting legal fees is so highly regulated, and there's a rule right on point, I mean, there's only one fee agreement between the law firm and the client here, correct?
Correct.
And the rule applying to fee agreements says it must be in writing and signed by both the client and the attorney and law firm. Period. That agreement must be signed, must be in writing, must be signed by the client and the law firm. That's what the rule says, doesn't it?
For fee agreements, but not for arbitration.
There's only one fee agreement, isn't there?
Correct.
There's only one agreement. The only agreement is the one, and it's not signed. And if you come outside of the legal realm and you look at it as a contract, it's a contract with two signature blanks, and only one is signed. I mean, if nobody signed this, you certainly would be trying to enforce it, correct?
If no one signed it, correct, Your Honor. But there's also the ability, if no one signs it, you can go by performance. So, when you have two signatures, you can also enforce a contract based on performance. And here, the lawyer made contact with the client, started the process of pursuing the claim, and for whatever reason, we didn't get to the facts of that here. The claim was not pursued. So there is case law that it has to be, you can go by performance, so you're not bound by that, And if you look at...
Performance doesn't take you very far in this case, does it? I mean...
We didn't get into the merits of the case because we were focusing on...
No, I understand. I understand there's a case within the case, but...
Right, and that'll, be developed, at arbitration, hopefully, or at the next phase. But for purposes of this thing, you can, and there's also case law that you could sign at any time. We're in a unique situation because my client was not able to sign it because they...
Excuse me? Your client wasn't able to sign it because why?
No, I was going to say, but right before trial. So we have the Corvette case where there was no contingency fee signed by the lawyer. The lawyer was able to sign it right before final judgment was entered, so they were able to collect the fee. So it could have been corrected. This is something that could have been corrected later on. They couldn't do that once the legal malpractice claim obviously was done because it was too late. So there would have been a big problem if you did that.
So you're not disputing that there was an attorney-client relationship? Because I saw your argument that if we affirmed that essentially when it went back down, the case could be dismissed because there was no attorney-client relationship. You're not arguing. You're agreeing that there's an attorney-client relationship.
I agree that there's an attorney-client relationship based on the meeting that they had to, and then based on the retention, and they have agreed that they've retained us. It's not like there's an issue that they didn't retain us. She signed the contract. She's agreeing that she's signing. She just argued that she's not bound by that contract because she wasn't the personal representative at the time. She became the personal representative later, which is a whole other issue. But for purposes of this contract, yes, there was an attorney-client relationship, and you can get that by signing the contract, by meeting. So I'm not arguing that, but what the argument was more that you have to be in privy to the contract in order to pursue a claim, to make this argument against us on a legal malpractice. If she never even stepped foot in our office and tried to hire us to represent her, then there would be no case. But so...
It's following up what Judge Boatwright's saying. So if we don't agree with your argument on the first issue, but we think the trial judge was wrong on the second issue about, well, they weren't a personal representative yet, so therefore that's another reason for ruling in their favor in this case. If we affirm, there still was an attorney-client relationship and they could pursue the malpractice claim, it just would be outside of arbitration.
Correct.
I mean, you wouldn't be able to come back and say, well, now that we think about it, we were never your lawyer, so have a nice day, you can't sue us.
No, I mean, she's agreed to signing it. She agreed
Right,
that
well,
she agreed that she
but
retained us, so yes.
I mean,
So-
the trial judge, maybe the trial judge was being thorough, I guess, at his or his mind, I guess, but the second claim, I think you're correct on, frankly.
And
You can spend your time, as I say apparently in every oral argument, you spend your time as you choose best.
no, I appreciate that.
And you talk to those guys about the second one.
So for the second argument, okay, we're correct on the second argument that she
Exactly.
signed, we're bound per Judge Lambert. So now we'll take it back and we'll go outside. You can also utilize the equitable estoppel doctrine, because there are a wealth of case law that says a non-signature can compel enforcement of an arbitration clause when circumstances permit, such as here. They're trying to sue us, they've sued us based on the relationship that they have because they signed this agreement and because they thought we were gonna pursue the claim on their behalf. And so if you look into the equitable estoppel doctrine, you can go ahead and follow the line of case law to then say, okay, a non-signatory can still compel enforcement of an arbitration clause. And I think you can sever, because I think there's a lot of contracts out, a lot of the case law out there that says you can sever, and this is not fatal to the claim.
But is this a different animal though, because it's an attorney fee contract and the Florida Bar regulates it, and the Supreme Court's pretty clear about dotting the i's and I mean, I get all the other cases. I probably have written something about severability of arbitration. I can't remember stuff I read anymore, but.
I don't think it's different, because I think you have to look at it, if this was an hourly agreement, the rule would not have required signature of the lawyer. It would just have, so we could have severed the agreement, because even with an attorney-client relationship in an hourly, you don't need that. And you can have an arbitration clause that is in that. And they could have had separate agreements. You could have had a contingency fee, 2 or 3
I don't
pages
think
on that.
my sense is we're not really disputing that you could have an arbitration provision in a contingency fee contract. The issue is, what's the significance of the lack of the law firm and lawyer signing that vis-a-vis the enforceability of that arbitration?
Well, if you look at all of the case law, all of that's on point as it relates to enforcing the contingency fee, it's about the collection of the fee. The point of this rule is to regulate the collection of fees. You have to have a writing signed by both, so that one party can't come back and say, oh, I didn't agree to pay you 33 1/3%. I didn't agree to pay you this, I didn't agree to pay you that, because it has to be clear. They have to understand up front. And that's why if you look at 4-1.5F, it details all the circumstances and all the things that you need to do to enforce a contingency fee contract. We are not enforcing the contingency fee aspect of the contract. We are enforcing the arbitration clause that clearly and undisputedly, unambiguously says it applies to anything arising out of this agreement, including a fee claim and including a legal malpractice claim. And it had the required notice verbatim to the rule 4-1I, and it bolded it, it underlined it, it did everything that we were supposed to do in that regard. And so in this particular circumstance, courts have, courts favor arbitration. They don't want to have cases in courts if the parties have agreed to arbitration.
Why do we favor arbitration?
Because why do
we favor?
No,
everybody writes that. I'm not sure why we favor.
Right, I think courts favor arbitration.
Trial judges probably.
It gets exactly, it clears their dockets, it's quicker,
We
it's
should
more,
favor arbitration.
it's more expedient. It's-
Oh, we do have mediation, that's right.
Yeah, there's mediation, there's arbitration, it gets cases off the dockets. So courts favor arbitration when there's an agreement, and they will enforce it. And per the rule, it should be enforced unless it's illegal or excessive. This contract was completely compliant. There's nothing in this contract that
Was the client ever given a copy of the contract prior to making the malpractice claim?
The copy, yes, the copy that she has was provided to her. That was attached, yes. And that was with her signature on.
I'm saying before the claim arose.
Yes. That's my understanding, that she was given a copy of it before the claim arose, but the argument is that she never got a fully executed copy. But if you read the actual language of the rule, it doesn't say, it just says a copy. It doesn't, a signed copy, it doesn't say signed by all parties and fully
Says the client
execute.
must be furnished with a copy of the signed contract and any subsequent notices or consents.
Correct.
So when it says that the lawyer, the law firm, and the client must sign it, I'm not sure I'd hang my hat there.
I'm not, but I'm just saying, it doesn't say fully executed, but she was given a copy, so she didn't know that she didn't, it can't say that she didn't know what she signed up for. And to say that there was no mutual assent, it's clear that there was no signature, like there's no initials or strikeouts or anything like that. So to argue that she didn't assent to the arbitration clause and she didn't know what she was signing up for, the language was clear. Everything was in there. And so I don't think that that argument, can go very far either. The main thing is whether or not the failure to sign, and in the state contracting case, the court went out and actually enforced a contingency fee agreement against a lawyer who didn't sign it and allowed them to have fees, and found that it was still enforceable and the lawyer was still able to collect fees as a contingency. The lawyer, tried the case and moved the case along to the end. So of course the client, couldn't say that the lawyer couldn't be paid. It was his lead counsel, but he didn't sign the agreement.
You filed a notice of related case with us?
I did, yes, Your Honor.
Is this another fair and
There is
unsigned
another,
contract
and the
case?
same contract case coming, and the court in that case found that it was enforceable, valid, and ordered arbitration.
And but it was unsigned by Fair and Fair?
No, it was signed by Farah and Farah.
Oh, okay.
It was signed by Farah and Farah,
Oh,
but it was
it's
different,
just
but they were
about-
arguing different, it was the same contract, they're arguing different arguments on it, but it's coming, I'll be back here
But it's
again.
not the arbitration thing, it's not about what wasn't assigned.
It's not a signature
Okay.
issue. Correct. This is unique, but really not. Actually, I've seen this many times where plaintiffs' lawyers have produced contracts and they didn't sign it either. So there is a problem, unfortunately, that sometimes people don't appreciate the rules as they should. And so I think in this circumstance, though, you can look to the case law that is there, that this is not a case where you're collecting on contingency fee agreements. So the Sandra's case should not be read as broadly as it has been read and as the trial court in finding it's completely void, because it was a different set of circumstances than we have here. This is a case that's more inclined to a technical or immaterial violation that does not prohibit them from making the legal malpractice claim. We're not trying to prevent that from occurring. We're just trying to enforce the rights that she signed by including the language in the arbitration clause, the notice that was a requirement. So it's important to go forward with that. If you look at the right.
Which again, as Judge
Oh,
Lemmer-
yes, you're right.
Judge Lemmer says you can use it however.
No, you're right.
You want to save it, now's the
No,
time. While you
perfect.
still have it.
Yes,
So-
perfect, thank you. I will
Okay.
reserve the rest of my time for well.
Good morning, Your Honors, and may it please the court. Brittany Ford and the law firm of St. Dennis and Davy on behalf of the appellee, Ms. Diaz de Arce, as personal representative of the state of Barbara McPherson. As Your Honors were correct to point out, a lawyer-retainer agreement is not, it is a different animal. They're not treated the same. In fact, the case law specifically says that these are not garden variety contracts, and that they are required to be viewed with stricter scrutiny than normal commercial contracts that typically contain arbitration clauses. And this is because as lawyers, we owe additional ethical obligations and duties to our client that exceeds what the common law requires of arm's length contracting parties.
Let me give you a chance to convince me why I'm wrong on the second issue.
On the second issue?
Here, let me do my hypothetical. Only joy left I have is hypothetical. So you walk in to hire Farah because on a wrongful death claim, you've not been appointed as the, I'm not talking about you, but the widow hasn't been appointed yet as the PR, but you're happy with Farah and you sign up. And let's assume Farah signs the contract here and does that, but you're not the PR yet. You're the PR among, they'll say, okay, we'll get the ball rolling, we'll get the PR, we'll get you appointed, no worries, you're the only heir of the estate, et cetera, et cetera. And you proceed and you get you win at trial, and now Farah wants to receive their contingency fee that you agreed to, that you as a human being agreed to. Is it really a defense to say, oh, by the way, that's really not an enforceable contract because I wasn't the PR at the time that I signed it, therefore I'm not bound by it, so you don't get anything under the contingency?
So the rule and
Yes or no?
Is it fair? Is that
No, I'm not saying fair. It seems the trial judge said, as part two here, well, you weren't the PR anyway, so it can't be enforceable because you're not the PR.
It's a fact-specific inquiry, Your Honor. That's why I can't tell you just yes or no. Because the rule and the case law says that these are, if a contingency fee agreement for a wrongful death claim is signed by someone who is not yet the PR, those are not automatically valid contracts. You have to do one of two things. You have to get that person appointed PR, or if that person is not appointed PR and someone else is, then you have to have your contract ratified by that person.
But that person was appointed PR.
Yes, Your Honor. 20 months after they missed the statute of limitations and 16 months after the relationship with Farah had ceased. And only in the context of us bringing this legal malpractice action. They shouldn't be able to reap the benefits of us taking action to ratify our contract after they'd already missed the statute of limitations and it's 20 months later.
PR had no authority at all. The child, the daughter, I think it was, who went to Farah, and you're saying, since she wasn't PR and didn't get appointed PR through Farah's efforts, she had no authority, she has no responsibility, you can't hold her, there's nothing here going on. How then is there the attorney-client relationship if there's no authority for her to do anything on behalf of the estate?
So the case law says that ultimately if the person who signs the contract provides a benefit to the estate, it still establishes a attorney-client relationship, and the firm, it's actually the estate of Pound's case. In that case, there were two law firms involved, two prospective PRs. The second prospective PR ultimately became PR and had signed a contract with a different firm. They never ratified the first firm's contingency fee contract, but the first firm gave the estate, I think it was $140,000 recovery on part of the claim. And so because they provided a benefit to the estate on behalf of someone who had a good faith belief that they could be a PR, and they provided benefit to the estate, the law firm was entitled to quantum mirror recovery, and it created the attorney-client relationship. So if there's those...
Well, if Farah had gone all the way to trial and lost, there would be no benefit to the estate.
But the establishment of an attorney-client relationship isn't actually determinate on what the lawyer does. It's on the client's good faith, belief that they've consulted an attorney simply for legal advice. The case law says that seeking legal advice is enough.
Right, but you're saying because she wasn't the PR yet, she had no authority to sign the contract, but yet she could hire the lawyer.
Because you don't need a written contract to establish an attorney-client relationship.
I understand that.
You're
saying she has the authority to establish the attorney-client relationship, but yet she has no authority to sign a contract.
I'm saying that the contract is not automatically valid until she became appointed PR.
And where does it say, what case does it say that Farah had to get her appointed rather than her being appointed through your firm's efforts?
So there is no case that says
that. Kind of what I thought, because the phrase you used was, you got to get her appointed, and I don't know the case that says you got to get her appointed. She needs to be appointed.
There is case law that says the rules contemplate that client consent and these requirements that we have to go through to validate our contract should be contemplated at the outset of a case, and that yes, you can cure these issues before judgment, but they say that you can't do when the case is 99% done. In this case, it was wholly done. They missed the statute of limitations. They couldn't bring a claim.
But the interesting argument or debate is, okay, you're saying, I like the judge's ruling. He said that I wasn't even the PR, and Farah can come back and say, okay, fine. You want to go that route? Guess what? How can you sue us for malpractice when you had no authority to enter into a contract with us to represent us because I'm no different than the guy who's walking on the street out here. I have nothing to do with this. So, all right, you get your Pyrrhic, I guess it's Pyrrhic victory here, and they come back and say, hey, we really, those guys at the 5th DCA just affirmed that. I guess we really never had a contract with you, so how can we be sued malpractice? Congratulations, we win.
Because the contract is not necessary.
That'd be an odd walk out the door today, wouldn't it?
It would, yes. It would be an odd one, I agree. But
I'm not saying that's what happened, but it's an interesting discussion following up what the chief was talking to you about.
yes.
Although I think your counsel professionally, your opposing counsel professionally can see that we wouldn't do that.
I can't say that the case law contemplates this exact scenario having occurred.
But
But it
let's
does.
talk about your void contract. Don't do that. You probably want to get off the schneid over here and do something else.
I will just reiterate that while the contract may not be valid, the contract is not necessary for the formation of an attorney-client relationship.
I get you. Go ahead.
Therefore, it's not necessary to bring a legal malpractice claim. Yes, so the contract is void in its entirety for the failure to comply with Rule 4-1.5F, which sets forth the signature requirements. The rule sets forth requirements that an attorney must do.
Well, yeah, if it was signed by Farah and Farah, would there be an argument as to why it's not an enforceable arbitration provision? I mean, it seems to be highlighted, it's in dark enough colors, it sets it out, and et cetera.
So the rule contemplates that these arbitration provisions have to be set forth in writing, and they have to be in bold. The rule doesn't say what that means, and the only case that really interprets the word bold in the state of Florida doesn't define it as a bold typeface. That's just one example of what it means. But what it does say is that it has to be set off such that it would provide notice. And it specifically says that it cannot be in the same style, type, and manner of the preceding thing. In this case, Farah and Farah's entire contract is in bold typeface. So the fact that their arbitration provision is also in bold doesn't actually hold to the spirit
Was it
of the rule.
underlined as well?
I believe it was underlined, but it's at the bottom of a whole bunch of other, it's at the bottom of a whole bunch of other bolded paragraphs.
That's where you signed though? It wasn't on page 3 and you signed on page 23, right? It was on the last page of the contract,
Yes, Your Honor.
right above the signature line?
Yes, Your Honor.
So if you looked at anything, it'd be kind of hard to miss it.
Yes, Your Honor.
There you go.
All right.
Yes, wasn't it? All right.
Yes, Your Honor.
But, your opponent keeps saying all the rule talks about is the fee agreement, enforcing the contingency fee agreement, and they're not trying to do that. So where's your case that says, and I know according to Justice Sasso, what must be, according to your opponent, clear dicta, you've got a case that says the whole contract is void. Do you have anywhere it simply focuses on the arbitration clause?
No, Your Honor, that specific issue as to whether or not a arbitration provision within a void contract can still be enforced has not been addressed by the appellate courts of this state. Neither side has found a case that specifically talks about that. However, the defendants, or the appellants in this case, do cite the Guy Bennett Rubin case, which specifically declined to answer the question as to whether or not other provisions of a non-compliant contingency fee agreement could then still be enforceable. It ruled that the whole agreement was void. And in fact, the case law says that no right can be founded in the courts of law and equity on the basis of a contract that's void against public policy for failure to comply with this rule. No right would include the right to arbitration. In fact, the Katz case says the agreement is void, period. And we would argue that the failure to comply with the signature requirements of this is not a mere technicality. In fact, the fourth found
Don't we
it.
have to be cautious in following dicta, though? I mean, I'm still having flashbacks talking with Mary back in the day about dicta.
So the statement that,
That's she used to be on the court.
yes, the statement that the agreement is void, period, was actually part of the main point of the holding in the Katz versus Frank Weinberg case out of the fourth in 2019. And in that case, the fourth actually found the signature requirements so important and so key to their issue that they actually voided this contract on their own. It was not an issue raised by either party on appeal. And the fourth said that just as the parties cannot stipulate to confer subject matter on the court, the parties to this appeal, by agreeing not to challenge the validity of void contract violative of public policy, cannot magically elevate it into one that this court will enforce.
Are we allowed to look behind the rule and ask why the attorney has to sign it?
So actually, the Shongus case addresses this issue, in that they
So we should look at legislative intent?
well, it's not so before, not legislative intent, court intent, because it was a court-generated rule, Your Honor. But they specifically said that there were so many issues with contingency fee cases, and that so they were mandating strict compliance to this rule to protect clients from incompetent lawyering, which I would argue is an issue here, given that we're here on a legal malpractice claim for a missed statute of limitations on a wrongful death claim. On
How does
contract.
signing help anything?
So it's to, it's so that the client is
If the
aware.
lawyer gets signed it, that doesn't seem to have been why the statute of limitations was missed.
No, but this contract on its own is sloppy at best. It lists the decedent as the client on the contract. So it lists Barbara McPherson as opposed to any of her children who could potentially be the personal representative. It lists blank the potential. It leaves blank the potential claims that are meant to be brought by Farah. It has her sign. It has Misty Arce sign.
I get all that. It could have been a much better job all around with everything, but is it up to us? Should we look at why the lawyer needs to sign it, or we just say the rule is the rule and follow the rule?
So the case law, arguably the case law says that these are requirements that a lawyer must do. The appellate courts of the state that says must means must. There's no wiggle room in that. So why they didn't or why they should is not necessarily the inquiry that we need to ask ourselves. It's did they? And they did not. And the Shoners case says that the rule commands that these requirements must be met. And they were not here. And the case law also says in the case of lawyer retainer agreements, in the event that there's a question as to the validity, it's construed against the lawyer and in favor of the client. And that they're not enforceable by the member of the bar, so the lawyer, who failed to comply, because the contracts are meant to protect the client, not the lawyer. And that's why.
So you could enforce it if it turned out, you could enforce it if you wanted to, even though Farah didn't sign it.
The case law does say that, yes, that it's meant, that it's not enforceable by the member of the bar, because it's not meant to be a shield against legal malpractice. There was a case in which an attorney fee agreement was not signed by the lawyer. Malpractice occurred, his client brought suit, and the lawyer tried to say, oh, you can't actually sue me for malpractice because I didn't sign this agreement. And the appellate court said that it's not meant to be a shield and a sword in that way, that it is meant to protect the client and it's not enforceable by the lawyer, but the client can still enforce the rights that they have based on a contract. I will, unless there's further questions for me at this point, I will rest on my remaining arguments and case law in my brief.
Thank you very
You'd
much.
like for us to affirm, right?
I'm sorry?
You want us to affirm?
Yes, I would like you to affirm the ruling of the judge, yes.
You don't want that to happen.
I don't want that, no, you're right. Lot to unpack, I'm going to say more for rebuttal. The Katz case that she referred to, where the court wrote that its agreement is void, period, was a situation where they were emailing back and forth. There was no contract. So this is not applicable here because we have an agreement. A violation of the rules regulating professional conduct is not meant to be a cause of action. It's not meant to be a basis for liability against a lawyer for failing to do so. It's an issue with the bar. You take it up with the bar if there's a serious material violation of the contract. This is not a question of using a shield and a sword to prevent us from allowing a legal malpractice claim to go forward. Instead, it's the opposite. They're trying to use it as a shield and a sword to say, well, on one hand, I'm not a party to it because I didn't sign it before I became a PR, and then I want to enforce it to sue you for legal malpractice, but you didn't sign it. And so they're trying to have their cake and eat it too, because they're trying to, create this basis to sue us and then say we can't be bound by the terms of the contract. But as your honors discussed the language in the arbitration clause, it complied with the rule and it indented it and it underlined it and it was right above the signature line. So it cannot be said that she did not understand what she was agreeing to when she signed this contract. So to protect the client, yes, the client needed to refer to another lawyer if she wanted to waive her right to pursue any claim against Farah and seek counsel. She signed off on that. That language is in here. The failure to...
Farah had, assuming it went forward, went to trial, everything else, never got signed for whatever reason, could Farah have enforced all the other provisions, such as charging back interest if there was financing on the case or investigator fees and all the rest of that?
Yes, and they could have...
The only thing they couldn't do would be the contingency fee, and then they'd be on quantum merit.
And correct, and they could have, according to the Corvette shop case, they could have signed it before final judgment was entered. Because there is time to allow parties to correct that because they want to be able to pay the lawyers, and the client should not get the benefit of going all the way through trial, getting a judgment in her favor, and then not paying the lawyer fee that she agreed to pay. And so there is time to do that, and there is a body of case law that says that a technical or immaterial violation such as this, where a party fails to sign the contract. There were also other cases where parties failed to sign a petition to collect on the fee, and the courts found that those were immaterial because that is not enough to invalidate the entire contingency fee contract. And so I would ask that the court reverse and remand because the ruling as finding that it was invalid and unenforceable as against public interest is not the case here. And the fact that the court also found that the PR could not be bound by this contract because she signed it 20 months later is also an incorrect ruling. So I would request that the court reverse and remand for arbitration and to stay the proceedings because that is the proper course to do so, to compel arbitration and stay the proceedings. Thank you, Your Honors.
All right, thank you. All right, thank you. We'll go on to our third case.